Hello. Making a last will is something that most of people postpone. Some out of superstitious considerations, some simply procrastinate, some think that they don't have anything of value, some think it's like too early to think about that. And that all might be right and correct, but unfortunately, there are situations when we pass away, like we people pass away suddenly without having enough time to make our affairs in order. Or sometimes before passing away, a person becomes mentally inept without knowing that actually. So the person might think that there is still enough time to make a will, but in reality, it's already not so much time. So there are many situations when, unfortunately, after a person passes away, his family, his close people, his dear people, or her dear people find themselves in a unpleasant situation, or at least complicated situation, or at least in some kind of trouble, exactly because there was no last will. Even more unfortunate is the situation when the person thought that he or she left a last will, but apparently it was not a valid last will. So, again, the people around, the family, find themselves in the same situation, and maybe those people who were not supposed to receive most of the value suddenly are in a position to receive that value, and vice versa. So, making a last will, making a valid last will, should be an important consideration, even if you think that you're quite young and quite healthy and that you don't have much of a property, just as a gesture of care about those who are around, and because very often, together with a last will, at least if it's a notarial last will, you have an opportunity to make a protection mandate. In a way, it's also a gesture of care of yourself in case, like, as they call it, in case of incapacity. So, how do you make a valid will? Uh, the Civil Code of Quebec recognizes three forms of valid wills, meaning that whatever does not fit within one of those forms is either unequivocally invalid, or there might be a trouble in an attempt to validate it before a court. The most bulletproof form of will is a notarial will, of course, the one made before a notary. And if you think that there is any consideration which might eventually be a reason for an attempt to invalidate your will, then going for a will before a notary is definitely the best choice. But of course, it's the most expensive choice. Making a will before a notary might easily go around $1,000, maybe less, maybe more, but something like that. So, but for a notarial will, which you make before a notary, there are other two options: a handwritten will and a will before two witnesses. And a will before a lawyer actually is considered to be one of the forms of the wills before two witnesses. Uh, the notarial will doesn't need probation before a court afterwards when a person passes away. The will before two witnesses, or the will before a handwritten will written by your own hand, those two need probation before a court. So again, if you want to deliver your close people from trouble, or at least from some kind of a burden when you pass away, then it's better to opt for a will before a notary. But again, a handwritten will and a will before two witnesses, those two, of course, are like less costly. So if you are making a will just in case, thinking that later on, when time comes, you will make a proper will before a notary, then at least you have two other options: a handwritten will or will before two witnesses. If you wish to make a will before a notary, you just find a notary, call, make an appointment, come for an appointment, explain what kind of dispositions you want to make and what kind of results of those dispositions you seek. Because sometimes you think that you just thought through it all, but when you discuss with a notary, you might realize that uh, the dispositions as you thought of them might come to a result that you did not foresee and actually you did not want. For example, you could think that if you leave everything to your, I don't know, sister because your children are for now like minors, thinking that it goes without saying that later the sister would deliver it to your children when they come to age of majority, the age of majority. Uh, it might be that your sister eventually, or her children, if he passes away, might see it differently. And it's not that I'm making that up. There are situations like that. So, if you go with a will before a notary, you have an opportunity to get a good advice and to think it through and to make particular stipulations and see that those stipulations are not contradictory. Because if you leave anything vague or contradictory in your will, again, it opens way for litigation among your heirs or among those who are left outside of the will. And that's probably something that you don't want to see or don't want to foresee in this situation. A handwritten will, it's the easiest one. So as long as it's fully written by your own hand, and there is a date and your signature and your name, and the dispositions there are unequivocal, meaning that it's clear from the text that it's written in case of your death, and the intent was to dispose of your property this, and this way. Then yes, it's a valid will as long as it's probated before a court. What are the caveats? Nowadays, not many people see our handwriting. And for the handwritten will, later there should be a proof that it was actually written by your own hand. Usually it's proven by an affidavit, a sworn statement of somebody who saw your handwriting, not like paper with your handwriting, but saw you writing at least something and hopefully a lot. So that person could see, yeah, I know this is his or her handwriting. Well, like 50 years ago, it was not a problem. Nowadays, unfortunately, there are situations when there is nobody around who could actually say, yeah, I can be sure that that's how he was writing. Even the signature, sometimes it's not so easy to prove, though at least that you can find in some bank documents, some checks or whatever. But handwriting itself, it might be a mysterious thing, even for your close people. So if you opt for a handwritten will, just make it sure that people around know your handwriting, because otherwise your heirs would need to hire a forensic expert, to prove that this was actually written by you, and it's expensive again. It's more expensive than a notarial will usually. The will before two witnesses requires, as you can see, two witnesses, and those should be impartial, independent people, in the sense that they should not be your heirs in this particular will, and preferably they should not be people related to the heirs. So even if one of the witnesses is not a husband of your heir, for example, but a boyfriend, at least at the time, and it could be proven, that might be a cause of making this will invalid, at least to question its validity before a court, and that's what you want to avoid. Again, one of those witnesses should be available later when it comes to to the process of probation, because that person would need to sign an affidavit that yes, he or she was present and he or she saw that how you signed this and how the other witness signed and how that this person also signed. Of course, this affidavit could be prepared in advance at the very same time when you sign your will before witnesses. But again, if you go for all those trouble already, all those complications, then you might as well opt for a will before a notary. Maybe that's why the majority of last wills available in Quebec are the wills made before a notary. What happens if you left something that you thought was a valid will? For example, you made a video recording of yourself just disposing of your property in case of your death. Well, unfortunately, by the Civil Code of Quebec and so far by the decisions of the courts, it's not a valid will. Same for an audio recording, even though it's quite clear that it was you and that's what you were saying, but for now, this form is not acceptable. Not sure about carving something on a wood or on a stone plate, but something tells me as long as it's not a handwritten will, though carving may be seen as a handwritten, but I'm not sure. But for now, it's more of a joke. As long as it's not a handwritten or before witnesses or notarial, probably it won't be valid. Going further, actually, there might be a situation when a notarial will is not seen as a valid notarial will. But the notary, him or herself, and some other witness were signing the notarial will. So if it doesn't go as a notarial will, it might be still probated as a will before two witnesses. Because, for example, if you're a deaf or blind person, there are some additional formalities that should be observed in a notarial will. If they were not, then the will is not valid as a notarial one. But again, it might be still seen as a will before two witnesses. Also, if the will was before two witnesses, but one couldn't be found, or one was actually one of the heirs or otherwise related, but the whole text was written by your own hand, it could still be probated as a handwritten will. There are mixed forms, like some of the text was written by your own hand, some was typewritten, was signed, or sometimes there is no particular date or signature is not clear or something like that. In those situations, the question will be always before a court. Is it a valid one or not? But the more problems you leave in such a document, the more precarious would be the bequest that you left to your heirs, one or another. Of course, there is a question, as I mentioned before, if at the moment when you prepared your will, when you signed your will, you had a mental capacity, basically if you understood what you were doing. Because a will, in a just broader sense, it's one of the forms of a contract, at least by the Civil Code of Quebec. And in that sense, a contract is valid if each party entered this contract like willingly, out of free will, so just really willing the consequences of this contract to happen as it's written, and in an informed manner, meaning that they understood what they were signing. Both actually apply to a will. So if later it could be proven that at the time you were already like too vulnerable, too sick, were not like even conscious, or at least it was very weak consciousness, heavily medicated or something like that, it all opens the the door to question the validity of the will. So if you think that you're already just of a certain age, or you have certain diagnosis, so there might be questions about that, it would be a good idea, first of all, to go before a notary, and second, to bring a letter from your doctor testing that at this particular point of your life, you're still mentally capable, despite of all your diagnosis, to continue with signing of this kind of legal document, like that you understand what's in there. This letter, a copy of this letter would be kept by a notary, and it's a good idea to have another copy and to pass it all together with a copy of the will to your liquidator, to the person you chose as a liquidator, so that again later everybody could avoid the unpleasant process of trying to contest the will. Now, if the will altogether is valid, formally, the form of the will is valid, and if your capacity was not in question, and if there is no question of duress or undue influence, and there is no question of a mistake, like arguing that you signed a will thinking that it was some other document, here again why the notarial will is better, because the notary is there to explain to you what are you signing. So it's presumed that there was no mistake, there was no error. You knew that it was your last will when you signed. So if those questions are not present, there is still, or there might be still, a question of an illegal or impossible clause or legal or impossible condition in your will. It happens if it's clear what you wanted, but what you wanted was against the so-called public order, so against the rules of the society, like legal rules of the society. One of the most famous is that if you leave a clause that your spouse could inherit only if he or she does not marry second time, that is an invalid clause, so this part of your will not be even considered written. It would be deemed unwritten. And if the bequest or some bequests in your will were based on this condition, they, depending on the language of the will, they might be seen as invalid, or they might be seen as unconditional. On the other hand, sometimes the wording of the will might make your condition in question, or your bequest in question. For example, you write something like, I leave this to my spouse, and later by the time when the will becomes valid, when you pass away, that person is no longer your spouse. So there might be a question, was it a condition that you that you bequeathed this property to him or to her because he or she was your spouse? And now if he or she is not, is your bequest still valid or not? Again, there might be some uncertainty, some ambiguity about that, which will probably bring the will before a judge again for interpretation. So if you want to avoid that, it's a good idea to think of it, think of the language, think of the possible interpretations of what you have written, while you still can make corrections in your will. There are some legal requirements when it comes to a liquidator. So even if you write that the liquidator is not obliged to provide an inventory, for example, the liquidator is still obliged to provide the inventory because the Civil Code of Quebec says so anyway. So as you see, you cannot write whatever in your will, or basically you can write whatever, but it will complicate the situation and may even invalidate the whole will afterwards. But on the other hand, in Quebec, there is a freedom to testate, meaning that there are no legal constraints on whom you can leave your property to. So even if you have Children, you can leave everything to your neighbor, for example, but remember that your children might later contest. So make it sure that it's bulletproof if you do it this way. You might prefer to leave something to a charity, bypassing again your children or grandchildren or even your spouse. But remember that some, at least, of your property, if there was no marriage contract, prenuptial agreement, or even something after your marriage, again signed before a notary, changing so-called matrimonial regime, like regime of your property in the family. So by default, when one of the spouses die, it, like legally speaking, it's, well, so-called equal to a divorce in the sense that some of your property would go to your spouse even before everything else is distributed according to your will. So if you leave something in your will to your spouse and think that everything else will go to the other heirs, it might not be the case, because something else will go to your spouse as if it was a divorce. Well, again, if you need more information on that in your particular situation, it would be a good idea to consult a lawyer or a notary or both. Also, the Supplemental Pension Plans Act says that some of the pension plans goes to a spouse even bypassing the will. So even if you think, or even if you had written in the will something about that, it might be still going to your spouse, or even de facto spouse, or a person who could prove that he or she was your de facto spouse, even if the name of that person is nowhere in the will. Also, if there was a life insurance or some other kind of insurance which would go to a beneficiary of that policy upon your death, for example, there might be a contradiction depending on when the will was signed, like after or before. But normally, by default, it goes to the written beneficiary, again bypassing the will. On the other hand, as opposed to many other provinces, for example, if you had a joint account with somebody, the money there does not go to that person automatically. It goes half to that person, half to the estate. Same about the property held together with somebody else. So, as you can see, despite of this famous freedom to testate, there are still constraints on how you can do that and what exactly you can dispose of and how, even if otherwise your will is valid. Therefore, again, if you think that those details are confusing, it still might be a good idea to go to a notary. At least it delivers the heirs and the liquidator of from many problems. Final thought is that if you go to a notary, then, as I mentioned before, it might be a good idea to ask at the same time to prepare your protection mandate, especially now when the law regarding protection regimes has changed, and there are more limitations on how your property and yourself could be managed in case of mental incapacity. It might be a good idea to make your own dispositions in that case while you still can, while you can still choose the person to take care of your persons, of your property, of yourself, maybe separately, maybe together. And do remember that if you just left somebody with your power of attorney, it does not mean that it's the same as the protection mandate in case of incapacity. Because once you are, God forbid, declared inapt, the powers of attorney that you signed are all invalid. What will be valid, if there was one, is this protection mandate, a mandate in case of incapacity. It should be, by the way, still homologated before a court, because, well, the idea is that it should not be easy to declare somebody mentally inept, legally inept. So, usually, when you think of a will, it might be a good idea to think at the same time that there might be another situation when you could no longer, could not any longer be in charge of your property and even of yourself. It's the situation of your mental incapacity. And nowadays, when people live longer, it's not so rare situation. And many people find themselves in a drastic, precarious, unpleasant situation because they didn't think of the possibility of mental incapacity before, when it was still possible to think of it. But that's another story. All in all, I'll conclude with the same thing I started with, that if you have at least some doubt, should you or should you not prepare your will, do prepare a will. At least a handwritten one and a one before two witnesses, and make it sure that all the interested persons have a copy of such a will, so that later there will be no problem. Thank you and have a nice day.